I did put in my resignation from the job too, but they couldn't find a replacement. So I gave them a specific time and to get it done. If they don't, then by all means, I'm gonna walk out. And before I walk out, I was able to release another individual, a juvenile, that kind of like a step, like a barrier, like, wait, Julie, stop. You need to go back and get more people out. That's why I'm still here. I'm here just trying to make sure that the agency understands how important it is to comply with all the court orders, which they have not done in the past or currently. I am here as a bridge and as a liaison between the ones that are in jail, because if I walk out, sometimes I wish you would just hold me in contempt, Your Honor, so that I can have a full 24 hours of sleep. What the fuck? I work days and night just because people are still in there. And yes, procedure in place right now sucks. I do, and I share the same concern with you, Your Honor. I am not white, as you can see. Hey, ¿qué pasó, amigo? Hey, mi español, hey! I am not white, as you can see. And my family's at risk as any other people that might get picked up too. So I share the same concern, and I took that concern to heart. But again, fixing a system, a broken system. Hold on 1 second. I'm taking a bite of my delicious Taco Bell chimichanga. Nom, nom, nom. Judge, please be seated. Would you please call the cases? Law clerk, we are here on 5 different matters. Case number 1, Segunda APG v. Pamela Bondi, etc. et al. Case number 2, Oscar OT v. Pam Bondi, blah, blah, blah. Okay, all of these are different. I'm guessing these are immigrant-related cases or whatever. All right. Can I have the parties first note their appearances, starting with the government? Miss Lee, good morning, Your Honor, Julie Lee, and with me, Miss Anna VOSS for the government. All right, good afternoon, you may be seated. And then for any petitioners, if you would state your name and which matter you're here on. Good morning, Your Honor. Kira Kelly here on behalf of Oscar and Juan. All right, good afternoon. Good afternoon, Irina Vaynerman from Groundwork Legal for Oscar OT. Good afternoon, you may be seated. The hearing this afternoon concerns compliance with court orders, not policy, just compliance, nothing else. I've had so many issues with non-compliance in just this past week that I called for this hearing. Today's focus is just on those that were attached to Miss Lee. So what I intend to do at this hearing is first to make some general remarks to set the table. Next, I want to respond to the submissions I received from Miss VOSS and Miss Lee within the last couple of hours. Then, third, I do want to hear from Miss Lee. Is it Miss Lee? On each of the 5 matters, the cases, to help me understand why the non-compliance and why it takes so many different communications and follow-ups from the court seeking compliance. It's pronounced lay. Gotcha. Okay. And then last, I'll have some questions for the government. The petitioners will have an opportunity to comment if they wish, although the focus of this hearing is the court's understanding, trying to reach some understanding with respect to non-compliance. What I really want is to fix it going forward. So the general comments, as I hope everybody here agrees and acknowledges, that a court order is not advisory and it is not conditional. It is not something that any agency can treat as optional while it decides how or whether to comply with the court order. The authority exercised by the court is derived from Article 3 of the Constitution and is not by dint of the parties' agreement with the ruling itself. That authority under Article 3 only has meaning if the court orders are obeyed, adhered to promptly, fully, and in good faith. That obligation matters most where liberty is at stake. Detention without lawful authority is not just a technical defect, it is a constitutional injury that unfairly falls on the heads of those who have done nothing wrong to justify it. The individuals affected are people. The overwhelming majority of the hundreds seen by this court have been found to be lawfully present as of now in the country. They live in their communities, some are separated from their families. When a release order is not followed, the result is not just delay. In some instances, it is the continued detention of a person the Constitution does not permit the government to hold and who should have been left alone, that is, not arrested in the first place. You all, that is the respondents, represent the United States. That carries obligations with it. The DOJ, the DHS, and ICE are not above the law. They do wield extraordinary power, and that power has to exist within constitutional limits. When court orders are not followed, it's not just the court's authority that's at issue, it is the rights of individuals in custody and the integrity of the constitutional system itself. So with that said, I want to respond to the submissions I received from Ms. Lay and from Ms. VOSS. And I received them just under 2 hours ago, but I want to address certain points with respect to those directly. The government makes the point that some of the attorneys currently are under extraordinary strain, and you are obviously telling that to this court, understanding that the operation that explains this process is not an operation that is driven by the federal courts. I do accept that Operation Metro Surge has generated a volume of arrests and detentions that has taxed existing systems, staffing, and coordination between DOJ and the DHS. I read that in your papers. I understand that. I also don't have any reason to take issue at this time that individual attorneys, including those appearing here, are working in good faith and under difficult circumstances. But those facts, even taken as true, do not answer the legal problem that it presents for this court. If the government undertakes an enforcement operation of this scale, one that results in the detention of large numbers of people, including individuals who are lawfully present in the United States, then the government assumes a corresponding obligation to ensure that each detention complies with the Constitution and with court orders governing releases. Volume, that is, the volume of cases and matters, is not a justification for diluting constitutional rights, and it never can be. It heightens the need for care. Having what you feel are too many detainees, too many cases, too many deadlines, and not enough infrastructure to keep up with it all is not a defense to continued detention. If anything, it ought to be a warning sign. But what you cannot do is to detain first and then sort out lawful authority later. Continued detention is not lawful just because compliance with release orders is administratively difficult or because an operation has expanded beyond the government's capacity to execute it lawfully. This court is not persuaded by the suggestion that detailed release requirements are the source of the problem. In many instances, I have had to not just issue an order, but another order, about 7 or 8 different touches sent to the government simply asking for the date, time, and location of the release of someone who was ordered released, in many instances a week or more in the past. And why that is so difficult, I cannot understand. Because there is obviously a person associated with the government who's going to the detainee to release him or her. You have their name. You can carry with you a form. The name is on it. Just write the time on it, and send it to the DOJ. That cannot be a source for this problem of the non-compliance, because that's too easy to fix, and I don't even work for the executive branch. But the requirements that the court has in place exist because individuals were being detained without lawful authority. They were being transferred contrary to orders or released in ways that undermine the relief that was granted by the court. The precision that the court here, not just me, but all the judges, the precision that we are requiring is not meant to be punitive, it's remedial in nature. So to be clear, this hearing is really not about trying to find ways to punish individual lawyers or second-guessing good faith efforts. It's about institutional compliance. So, Ms. VOSS, I don't take it at all that it's the government's position that Operation Metro Surge has outpaced the government's ability to lawfully process detentions and comply with judicial oversight. That's not the government's position, is it? No, certainly not, Your Honor. Right. And does the DOJ feel that just because it has or needs resources to process all of the claims and comply with court orders, that is a reason for the court to be relaxing constitutional requirements? No, certainly not, Your Honor. So I do take compliance seriously. And as the government well knows, you may be seated, if you don't comply with the court's orders, you've essentially painted the court into a corner, because what are we supposed to do? We're here to determine what the law is, and we're here to sort out whether the detentions were lawful or not, and issue orders for releases if we find the detentions were not lawful, and oversee that they get executed. And when that does not happen, well, then here we are. And in our case, the court has had hundreds of these at this point, and the court is busy too, and made all the more busy if on a given day we ask, within 48 hours, to be notified of the date, time, and location of the release of someone who's been ordered released, to receive nothing at the time that has been ordered, send a follow-up and receive nothing, send another follow-up order, and then receive a response that doesn't answer all 3 things. You might get 1, you might get 2, and then you have to respond again, and in some instances, find that the person hasn't been released at all, as had been represented. And all this really means is that what should be a straightforward order, we've heard the arguments, we've found the detention to have not been lawful under the circumstances, person should be released, we find just repeatedly that that's not enough. It takes repeat after follow-up with the government, and we'll see some of those in just a moment when we go through the matters. So I'm going to stop there just by way of background and follow up on the responses I received from Ms. Lay and from Ms. VOSS. And if you want to come up to the podium, Ms. Lay, yes, Your Honor, I would like to walk through the 5 matters and get a better understanding of what the issue is and what we might expect going forward. So if we could start with Segundo 26603. Your Honor, may I approach? I would like to present some. You've approached already. Thank you. Documents handed to the court. So that's the first case, Your Honor, that I have in front of me here, and I tabbed it so it'd make it easy for you to kind of follow. I have the case material in front of me here as well, so you can proceed. So I received just to have some background, I was put on this special mission to help with the U.S. Attorney Office with all the habeas claims that they have received. They are overwhelmed and they need help, so I have to say, stupidly enough, to volunteer. I started with this agency on January the 5th. As of today, it's been more than 4 weeks. I just got my PIV card to the DOJ system yesterday. Where were you working before? I was working for the Department of Homeland Security as an ICE attorney in the immigration court. Okay. So on January 5th, when I started with the agency, I have to be honest, we have no guidance or direction on what we need to do. And so when you showed up, they just throw you in the well, and then here we go. I was tag along with attorneys during my first week of my assignment there. So this one here, the first case, was assigned to me actually on January 26th, which is about the third or fourth week of my job. I received the assignment on the 26th of January at 11:14 a.m. I filed the response immediately at the same day at 4:08 p.m. Okay, so they were hired, filed the response within 5 hours. And during that time, the respondent already had been transferred to Texas, and it was at around 2:37 p.m. I mean, I apologize. It was not transferred to Texas, but the respondent was transferred from Texas to the Whipple building at around 2:37 p.m. And then he was transferred from Whipple building to Sherburne County Jail on that same date at around 5 p.m. That's the timeline that I was able to see in the system. I received your order, and I sent it out just a few minutes shy after he was sent back. He was sent from the Whipple building to the Sherburne County Jail. I sent it to them at around 5:38. I did not receive the order with the how the agency's set up. Usually our paralegal received the notification, and they sent to me for review and processing. And with everything going on, I did not receive the order until it was too late. The next order that showed up in my email inbox, it was on January 30th. That's when you have an order for us to question about where about this party, where about the petitioner, right? I sent a follow-up, if I may. Yes, this began with an order that granted the habeas release and ordered immediate release on January 27th from this court. Quote, respondent shall immediately release petitioner from custody. Within 48 hours shall file an update on the status of petitioner's release, end quote. And that would have been on January 29th. There should have been a notice provided. There was no 48-hour update that was filed. And then on the 30th, there was a text order from me ordering to file an update, reminding that there was an order to file an update within 48 hours, and then saying, file a letter by no later than 5 p.m. on the 31st, showing cause why there shouldn't be contempt held for violating the court's order. January 31st came, no letter was filed by 5 p.m. either. And then on February 1st of 2026, petitioner's counsel, not the government, petitioner's counsel filed a status report stating that the petitioner still had not been released, although immediate release was ordered on January 27th, and he was here in Minnesota. And then, February 2nd, there was an order to show cause from this court ordering respondents to immediately file an update regarding petitioner's release. And then, on February 3rd, a day later, there was still no immediate update, no written memorandum filed, and then we learned that the petitioner had been released on February 2nd at 10 p.m., in which we learned from a representation that was made in a different case, not in the Segundo matter, we learned he'd been released on February 2nd at 10 p.m. Still, no direct response to date, time, location of the release, and so that's what led to the order to show cause. As a quick thing, unless there's a legal matter that I'm not understanding, there might be, just because I don't know how all this shit works for the federal court system and everything. If you're not going to issue contempt orders, then nobody's going to fucking respect you. You have the most limited amount of power as a judge to do something to enforce these. If you're not going to issue contempt for anybody and you're just going to let them come all over your court over and over and over again, whether it's them coming or whether it's them getting fucked in the ass by their bosses at DHS and then coming and dropping that load off into your mouth, then no one's going to fucking do anything. I don't know, unless maybe there's some reason why they can't be more aggressive with these contempt orders, because I understand this attorney is obviously backed up or is obviously getting fucked because the government sucks at their job right now because the Trump admin has no idea what they're doing. But attorneys should be afraid to take these jobs then. They should be worried that if I take this job, I'm going to get fucked by the courts and they're going to start holding me in contempt because I can't do my job. And so the admin should have trouble staffing these jobs. It shouldn't just be that they'll find any random person, throw them in, and then the person's like, fuck, I can't even do my fucking job. I don't have the resources to do it. And I hear, the concerns that are raised by the DOJ with having to comply with the specificities that the court is asking for. But look how much trouble it takes in response to a simple inquiry to file an update on the status of petitioner's release on January 27th. The court had to ferret out its own answer, in essence, days later on February 2nd. What can the court expect going forward? Because this is obviously not workable. And it's certainly not an example of complying with the court's order, unless you feel it is. No, I don't feel like that it is at all, Your Honor. And I'm trying my very best to help to come up with a system or, a procedure somehow so that we, the SAUSA people, SAUSA, something attorney USA? What does SAUSA mean? Special Assistant United States Attorney. Gotcha. Thank you. Taking on the detail can help moving it forward and smoothly and in complying with the court. And I'm not defending all the mishap on the case, but what I can tell you too is, Judge, that most of the email was sent to my DOJ email, and I did not receive it until it was too late. And I still am having trouble accessing my DOJ email. So everything, if it was in my ICE email, then yes, I receive and I will respond. If it's sent to a DOJ one, I don't have a way to access that system. But as for moving forward, what are we going to do, Your Honor? May I approach? So I guess they haven't gotten there, or it took them a long time to get their credentials to the new inbox, or whatever they had for this transfer to help with all of the pending cases or whatever. Holy cringe. Yes, you may. Thank you. Here we go. Thank you. Documents handed to the court. Your Honor, those are a couple of emails that were sent to me from the petitioner's counsels of how hard I try to be in compliance to fix the system and to get the person released. And if you will flip to the last page during my first week, I don't want to say the number, but that's how many hours I put into this work because I did not know what I was expected to do. On the second week, the number, wow, what's up, little guy? Thanks for giving the subs. On the second week, the number increased almost double, Your Honor. So are you telling the court that you were brought in brand new, a shiny, brand new penny into this role, and you received no proper orientation or training on what you were supposed to do? I have to say yes to that question, Your Honor. Right? All right, you can proceed. Okay. And so I slowly figured out what it is that needed, what is it that needed, and what the requirement that we need to do for the full lifetime of a habeas from the start of the petitions that when we received it until the end. And since that point, on this last week, that's when it's like, okay, this is the process. So I do now have a process in place going forward, what we need to do so that we can comply with the court. And as the court can see, those emails are evidence that it's working. So is this then each attorney within your office making up his or her own process? I don't know about that, Your Honor, but as the SOSS attorney, special attorney, supporting attorney, what was this again? Special Assistant United States Attorney, okay. As the Special Assistant USA's attorney, there are 4 of us, and we are trying to figure out what do we need to do to handle this operation. All right, let's proceed to the next case if we could. Yes, and I would like to next... as to the next case, may I approach Your Honor? Yes, I'd like to hear about the Oscar case, Oscar 26167. Yes. Documents handed to the court. The judge says, I suppose by way of protocol, it would be proper to have shown what I'm receiving to the petitioner's counsel. So if you would, hand that to them. Did you have a copy for Miss Lay says, I don't because I have not redacted all the information, but these are the email and the correspondences that I have worked on this case. And it shows that we are not lacking of not following up or not doing our job. Well, if you have unredacted sets of information, I'll tell you what, I'm going to return it to you. Okay. And I have my own materials and facts on the case here anyway. I'll just give it back. Thank you, Your Honor. So for that, again, okay, this is Miss Lay speaking, the special attorney. Okay, so for that, again, it was during the assignment in the second week on the job. Again, at this time, I have not sworn as a U.S. attorney to present or have cases in front of Your Honor, so everything goes to the chief. I get nothing, no notification, nothing at all, except for whatever that was sent to me to work on. I received the assignment on the 12th, and I sent a follow-up email to the Office of Principal Legal Advisor for documentation and for declaration for the Deportations Officer Declaration, and on the 14th, I filed my response to the court. I received the court order through all the email exchanges within the office because the paralegal will receive it, download it, and they will send it to me. On the 17th, 3 days after I filed my response, I received your order, Your Honor, at around 10:12 a.m. So let me stop you there. Yes, because that January 17th date is in my timeline also. This petitioner that I referred to as Oscar here was, again, a petitioner who had no criminal history that warranted mandatory custody, and he was apprehended by ICE on January 10th of 2026. On January 15th, there was an order from this court that he had been ordered released, and respondent shall confirm the date, time, and location of petitioner's release within 48 hours from the date of this order on the 15th. January 17th, which was the date you are referring to, is when you first received the order. Received the order because it didn't get to you within your office? Yes. There was no 48-hour update that was filed on the 17th, and then on the 19th, 2 days after that, the court writes again, respondents were ordered to immediately release petitioner from custody, Minnesota, and to confirm the time, date, and location of release within 48 hours. That hadn't happened. And so then the court is saying that I wanted a letter no later than 3 p.m. on the 19th showing cause why you shouldn't be held in contempt for violating the court's order. Then on the 19th, I'm told the petitioner was scheduled for return to Minnesota on a flight from El Paso on Tuesday, January 20th, 2026, and that he would be released upon his return. That was on the 19th of January. On the 20th, I write, because we'd received no notice that the release had taken place, respondents state that petitioner is scheduled for return and release in Minnesota on January 20th. Respondents must file an update by the end of the day on the 21st, is what I'd ask for, stating the status of the petitioner's release. Then we learn that on the 20th, when the release was supposed to have taken place, there was no release. Instead, we're told that counsel for ICE had represented to petitioner's counsel that the petitioner was currently on his route stop in Albuquerque, New Mexico, not El Paso, Texas, and is scheduled to arrive in St. Paul on Saturday, the 24th. And this is already then 9 days after this person has been ordered released and found to have been unlawfully detained in the first place. So 9 days later, he's still in custody, now being flown around from El Paso to Albuquerque, New Mexico. So the petitioner's counsel then files a motion for contempt because of the facts as I just stated them. On the 21st, I ordered then Ms. VOSS to file a written response. I'm sure she's had more than one day where she regrets how well I know her name, since most things end in, get a hold of Ms. VOSS. But I ordered respondent's counsel, Ms. VOSS, to file a written response by 4 p.m. on January 22nd, providing the factual basis for why I was told in the first place that the petitioner was scheduled to return to Minnesota on the 20th on a flight from El Paso when he, in fact, remained in ICE custody in Albuquerque, New Mexico. Ms. VOSS responded on the 22nd, explaining the timing of when she learned the facts. And let me pause there to make another point kind of clear enough. I wholeheartedly embrace the notion of a unitary executive, as in DHS, ICE, the DOJ, all a part of the executive branch. And if there's a problem in the restaurant, I don't intend to go into the kitchen to try and figure out who makes the bread. And all of it is part of the executive branch. And when someone offers you water, I'm just kidding, sorry. And so it is not an excuse to tell me you contacted ICE, because ICE is also part of the unitary executive for accountability purposes. But in any event, on January 24th, there was no confirmation of release filed, stating that he had been released on the 24th either, 9 days later, and in fact, he wasn't even returned on the 24th. So then on January 26th, we're still at it. And again, I'm here referring to an order for release that was on January 15th, state the date, time, and location, and this is the follow-up I'm still having to do because I still don't know. So then I hear from the government and order the government that the government on the 26th must file an update by 4 p.m. on the 27th of January, confirming the date, time, and location of petitioner's release. On the 27th, I hear from you, Ms. Lay, and, quote, I want to inform the court I've received confirmation regarding the petitioner's itinerary and confirm that petitioner will be transported back to Minnesota via a commercial flight today, end quote. However, due to safety concerns, you asked for an extension of time to provide an update on his release today prior to midnight, and at which point I granted the extension of time and asked that an update confirming the date, time, and location of the release be provided no later than 10 a.m. the next day on the 28th. 15th ordered release. Now we're on to January 28th, 13 days later, for someone who was not lawfully detained in the first place. So then on the 28th, Ms. VOSS requested a brief extension because they had not received the prior order until later in the day, which was an issue, I think, with the notice from my clerk's office with providing that notice. And so then we wanted the updated response from the government by 8 p.m. on January 28th. On January 28th, I do hear from you, Ms. Lay, at 9:17 p.m., stating that, guys, don't be late on this, okay? You want to be able to write that on your motion? I don't know, maybe this doesn't matter for criminal stuff, petitioner responded timely, but whatever, okay. Especially when you're already fucking 2 weeks late almost. On January 28th, I do hear from you, Ms. Lay, at 9:17 p.m., stating that petitioner was released on the 28th at 4:30 p.m. in Minnesota. I'd also asked for information about what the safety concerns were, and you don't have to say what those were. It's enough to say that I asked about what the safety concerns It's enough to say that I asked about the safety concerns then. I followed up in 2 other follow-ups from the court asking what were these safety concerns that explain this delay. And to this day, I've never gotten an answer despite the follow-ups with the court. And I've put that issue under seal, so it need not necessarily be discussed in open court, but I've gotten no responses at all for what the safety concern was. And Ms. Lay, am I right that and then Ms. Lay says, you are correct on the dates and the time. And yes, on the 27th, when he was supposed to be landed in Minnesota, St. Paul, Minnesota at 9:31, I waited for a few minutes to make sure the plane landed, and then I check the airline. They say the plane was landed safely and actually a few minutes early. So I reach out and check again to see where's the respondent so that we can get him, or not the respondent, but the petitioner. They're the respondent, but the petitioner, so that we can get him released, and found out that he did not make it on the flight because the airline declined to let them on board. So how do you have to wait for them to land and know that? So I escalated to the higher up, and I also put it in my 24 font, this needs to be done. And I asked for another commercial airline, and that's who was on board the next day to land there, Your Honor. But my question is, and I just wanted to answer, Miss Lay, please, yes. Miss Lay, you're not to talk over the court. If I'm asking in writing, and then having to pick it up multiple times thereafter to follow up with follow-up questions because I've never gotten an answer. Have you not to this day provided a written response as requested by the court as to what the safety concerns were? Why did you not respond? I draft a letter on the 28th a long letter and send it on to my superior so that they can, actually send it on to my paralegal so that they can file it with the court with all the flight information and everything else in that. But Ms. VOSS already told me that she took care of updating the court. Therefore, that letter was never sent. Oof. Okay, hold on. A few things. This is good, like life advice, and obviously would apply to lawyers, but really for anybody at all. There are, on the order of annoying things, other corporations and other management might feel differently about this. This is how I personally feel for any of my employees, and this is how I feel like everybody around me feels. Here are the 3 most annoying things that can happen, rated at how annoying they are. So at 0, we'll say this is not annoying at all. At 100, we'll say that this is the most annoying thing possible. So at 0, it is you're on time. Okay, good job. Perfect. At 0, you're on time. Now this varies based on the thing, but we'll say from 15 to 40 on the level of annoyance, you are late, but you've given some kind of notice. Then we blow past 1,000. We blow past 100 to 1,000, and this is late with no communication. And now I understand sometimes as an employee or a person, you feel bad sending in like a text telling your boss you're going to be late, or communicating via email or Teams or whatever fucking shit you guys do. Like, I really hate that I'm going to be late here. And in your mind, you might think, okay, maybe they're not tracking this at all, and I can just like turn this in like a day late and they're not going to notice. That in the world where that's true, you saying that you're going to be a day late doesn't hurt you, okay? This is so annoying to not communicate it. You being late on a thing, especially if you have even a semi-valid reason, and especially if it's not like a fucking like a JIRA class Alpha Delta ticket that's causing revenue disruption across a multi-trillion-dollar market cap. As long as it's not the worst thing in the world, just, hey, I'm running behind on this. I need 2 more days. Or, hey, I was going to show up here. I'm going to be 40 minutes late. Fine. Go grab some fucking donuts. Or if there's a meeting you're going to miss, we'll take notes for you or whatever, I guess. Okay, at least we know. Having everybody in limbo because you're not communicating, you're not saying anything, there's no notice given, is so much worse. This is so much worse than just being late and giving notice, okay? In every environment I've ever existed in, this has been true. I'll caveat and say maybe in some environments, maybe it's not, but in every environment I've ever been in, okay? Just notify people, all right? Just notify people, all right? Also, there needs to be a clear point of contact or a clear line of communicate. No, you just have a single point of contact. This idea of like, well, I was going to send it to this person, but then I was going to send it to this person, but then they said they already took care of it. That if I'm entering an environment where other people are working and I ever hear that, that is the number one dysfunction red flag to me. When I hear somebody say something like, let me do something, or I'm going to do this, or blah, 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 and then somebody else says, oh, don't worry, somebody else already took care of it, I only need to hear those 2 things to know that this whole environment is fucked from top to bottom. It is the worst thing ever to hear that somebody did a thing and nobody else knows that person did a thing and somebody else thought they had to do the thing. Because for anything like that to happen, there has to be so much managerial and communication dysfunction. Oh my God. Okay, sorry. Anyway, so the court is not getting any answers back on anything. Shit is getting fucked. Okay, so this letter was never sent. Gameplay student, thank you for tier 4 summon, buddy. 3 months straight. All right, so that letter would have explained to me what the safety concern was? Well, the letter was including the flight information for each and every single departure. Oh, they're doing the debate tactics. The debate. Miss Lay, Your Honor, not Miss Lay, please, Miss Lay, please answer my fucking question. Did the letter explain to me what the she didn't say fucking. Did the letter explain to me what the safety concern was, since that was my question? No, that's enough. Shut the fuck up. Thank you. Then you can go back to my other question, which was why. This is why I said I like the court process, right? You see how simple this person was about to fucking say a whole bunch of random, irrelevant, retarded shit. They were about to say some random, stupid shit. Hey, would the letter have told me what the safety concern was? Let me tell you about this letter, okay? This was the best letter you've ever seen. Shut the fuck up and sit the fuck down. The answer is no. Yes, Your Honor. Then you can go back to my other question, which was why, if somebody's ordered released on January 15th, and they're not released for 13 days, January 28th, based upon a purported safety concern, when the court asks what was the concern, why, after multiple requests, have you not responded to explain what the safety concern is, since a person unlawfully detained was kept in detention behind bars for 13 additional days and no explanation had been given? Why not a response? The reason that I did ask, and I was told if we provided all information, the protester will show up at the airport and the agent and other people will be in danger. That's why you can't update the court? There's no way to file any of this under seal? There's no way to pass this off as confidential? There's no way to have does she think the judge is gonna post it on her Twitter account? So I took it to heart because during that time, what? It's like you're just admitting to lying to the judge. Well, somebody told me that I can't tell you shit, motherfucker. Why would you say this? Why would you say this? So I took it to heart because during that time, it was very heated here in Minnesota with all the protests that was going on. Any public thing that was going on is at risk. Even myself is also at risk for putting my name and myself in here, Your Honor. That's a safety concern that I have. So my question had to do with the safety concern for why the person could not be put on the airplane in presumably Texas or New Mexico or wherever he was at the time. And is your answer because they were concerned that if he were put on a plane, that if he arrived here, there may have been a public reaction of some kind? Your Honor, he was escorted with other agents. He wasn't put on the plane by himself. The original plan was to have agent escort him back. And with the protests was going on during that time, I was advised to be careful of what information to put out in public so that for the safety concern of others. So I'm not altogether following, since I was told that the safety concern was one the airline had raised. Well, as for the airlines, I don't know why they denied his boarding and the agent boarding. I don't know that, but I know that they were denied. Hold on, but you said earlier you represented to the court that he was denied for safety reasons. Now you're saying you have no idea? I have the tickets, and I was going to present it to you with the tickets that it was bought for him and the agent, but they were both denied by the airline. And when the various persons are detained and then flown to El Paso or New Mexico, are they flown out of here on commercial airlines then? I don't know, Your Honor. I don't know how to answer that question. Do you know that they are flown out of Minnesota sometimes within hours, if not the next day, of being detained? Yes, I know that they are doing that. And do you feel there's anything wrong with taking hours or days to fly them out of Minnesota when they've been, oh yeah, definitely, just a minute, let me finish my question. Yes. To fly them out of Minnesota and then take 13 days to return them when they've been found to have been unlawfully detained? Your Honor, I did ask the same question too. I have not gotten the answer. All right, let's talk about the next one, which is Jose. That is number 26244. And in this particular matter, for the petitioner known as Jose, again, there was nothing in the record that reflected that he had a criminal history that warranted mandatory custody, and he had also been then released or ordered for release on January 15th, 2026. And there had been an order that there had been an order that there be an update filed with the court within 48 hours, just confirming date, time, and location of release. That he was not released at the 48-hour update. I received a notice on January 19th from a letter filed by Ms. VOSS, and this is after, by the 19th, I had already put into place a show cause order since there had not been compliance with the court's order to verify date, time, location of release. Then on the 19th, I hear from Ms. VOSS that petitioner was released from detention on January 18th, 2026. Now, the problem there, and I won't talk through all of the additional times I had to communicate with the government with respect to closing out the unconditional release order of Jose, but suffice it to say, the dates included January 22nd, January 30th, several of them on January 30th, because what I learned was that in the case of Jose, who had been ordered to have been released without any conditions, I learned that the government had imposed conditions on his release that were not a part of the court's order and that were not imposed based upon any consent agreement, order from the court. Is that accurate? That is accurate, Your Honor. And then your office has to then engage in more efforts because those conditions have to then be struck because they weren't ordered by the court. Is that what you had to do then? I have to go back and pulling teeth to get things fixed, and it took a long time. For a long time, the ICE agency is working under the immigration court, and they have their own policy and procedures. To get my back home colleagues up to date that federal court is not the same as how immigration court operates, it took a long time, and many ordered to show cause to explain and let them know that, come on, if you guys don't fix it, I'm going to quit, and you're going to be dragging yourself into court. I have to say that too in front of that in order to get it fixed. Do they not know? So a show cause, Kafka, correct me if I'm wrong, but I believe essentially a show cause is just the court ordered you to do a thing, and you seem to have not done the thing. Now, I could fine you, sanction you, or I could hold you in contempt, or fines and sanctions might be a result of being held in contempt. But I'm going to file a show cause, and what the show cause is it's going to give you an opportunity to explain to me why the fuck did you not do the thing that I told you to do, right? So maybe you're ordered to update the court by January 10th, and maybe you don't do it, and then the court issues you a show cause before sanctioning you or fining you or holding you in contempt, right? And you say, hey, by the way, I got into a huge car accident yesterday. I couldn't contact anybody. I was in the hospital. Like, I'm so sorry. It won't happen again. Blah, blah, blah. Here it is. I've done everything I can, right? This is a show cause. Show me a reason why I should fuck you, okay? Give me a good reason not to fuck you. That's essentially what a show cause is. So she's complaining. Apparently, the good old boys back home think that their immigration courts are the same thing as real courts. They're not. She's having to explain to them, guys, we have like the real courts that we still have to talk to. I know that's irritating you guys, but we still have to deal with the real courts. Okay. I did put in my resignation from the job too, but they couldn't find a replacement. So I gave them a specific time and to get it done. If they don't, then by all means, I'm going to walk out. And before I walk out, I was able to release another individual, a juvenile, that kind of like a step, like a barrier, like, wait, Julie, stop. You need to go back and get more people out. That's why I'm still here. I'm here just trying to make sure that the agency understands how important it is to comply with all the court orders, which they have not done in the past or currently. I am here as a bridge and as a liaison between the ones that are in jail, because if I walk out, sometimes I wish you would just hold me in contempt, Your Honor, so that I can have a full 24 hours of sleep. What the fuck? I work days and night just because people are still in there. And yes, procedure in place right now sucks. I'm trying to fix it. As you can see, the email that I sent to you, it has been improving, a great improvement. And last night, I had to stay up until 2:35 a.m. just to get these documents ready for you. I'm not trying to throw big attorneys under the bus. My understanding is like when you're a big attorney for civil or criminal stuff or whatever, usually you have like associates and junior attorneys and stuff that are working under you to like kind of get the busy work together. Like it's still your responsibility to understand the material well enough to present it to the judge, and you might have like a personal hand in really big matters. But like, I feel like if you're at a case where your lead counsels on things are like staying awake until 3 a.m. to get paperwork ready, shit is fucked. Your shit is mega fucked. Jesus Christ. Then again, I don't know the graveyard that is the DOJ. I don't even know how many people are still staffed there anymore, but yikes. Have you covered why immigration courts are so different? It is just the volume of cases or the lesser nature of crimes. So I didn't fully understand this even until we watched this video yesterday, and I had to dig in more to this because this just sounds retarded to me. When you talk about courts in the United States of America, courts are established by Article 3 of the Constitution in the judicial branch. Immigration courts are Article 2 courts, which are not real things. I don't even know why these are called courts. I don't understand this. I would have to do significantly more reading because this sounds insanely fucking retarded to me. But there are Article 2 courts. The reason why, in my opinion, this is retarded is because in a court hearing, for a layman, we all kind of see, or maybe a lot of people do. I don't know how many people still do. I've been so into all this law shit or whatever now. Maybe I'm underestimating the average person, but people see kind of like the prosecutor, the police, the judge, the court are all like the same thing. They're not. The court is supposed to be an adversarial party to both people that are presenting a case before the court. So when the government is coming after me for something, and when I'm defending myself, both of us are defending ourselves in front of a neutral or adversarial third party, the court. But these Article 2 courts are, the president basically arrests you for doing something bad for immigration, and then you go in front of the president to tell you what if the case that the president is presenting is good or not. So you're like, imagine the prosecutor is also like, he gives the whole argument to the judge, and you're sitting there, and then as soon as he finishes his argument, he puts a wig on, and then he goes and he sits in the judge's seat, and he's like, good argument, government. You make a fucking killer case there. Defense, you're fucking retarded. See ya. I don't understand it. I'm sure there's a more sophisticated legal argument for why this was ever okay. I don't know if Article 2 courts even existed before ICE, before 2003 or whatever. I'm not sure. I have no idea. I don't know. Destiny, it's a judicial economy thing. There are too many claims, and the vast majority of them can just be resolved by operation of law. The IJs or ALJs are just making sure the operation of laws happen. If you're in one of these Article 2 courts, you can appeal it to an Article 3 court. So Kafka, we probably agree on this, right? I think that, like, first of all, I would still give it a different name because it's weird. And I think maybe we would agree in practice, or no, I'm sorry. Maybe we would agree in theory. But it seems like the issue now are these Article 2 courts are issuing things that are seemingly things that should probably come from Article 3 courts, right? So like the ability to issue a notice for deportation, right? Like, hey, we looked over this, you can deport this guy. Okay, cool. What does that allow a federal officer to do? Well, I have you here and we can begin the deportation procedure. But now, when you're getting also the Article 2 executive to say, you know what? These things here that we've decided are issues for deportations, these are actually going to just double as search warrants. We're going to let people go into your homes and shit with these things. Fucking excuse me? If you want to enter my property, okay, we're in big Bill of Rights territory now. I need an Article 3 judge to sign off on that. Fuck you. The executive is going to sign its own fucking search warrants to get into my domicile? That's crazy to me. But maybe I'm retarded. I don't know. That's crazy to me, in my opinion. I just don't understand that. And this whole thing of like them stretching out what can be done with some of these Article 2 orders is wacky. And last night, I had to stay up until 2:35 a.m. just to get this document ready for you. I can't say it's a waste of my time, but I could have sent so many more emails and gotten so many more people to get ready to be released. And I'm here with you, Your Honor. What do you want me to do? The system sucks. This job sucks. And I'm trying every breath that I have so that I can get you what you need. This is like some fucking litigant pro se shit. This is like a guy who's like, I wanted to represent myself, now I'm fucked. This is a federal court, and this is a U.S. prosecutor who's just like fucking rage posting in the well. What was it? Sometimes I wish you would just hold me in contempt, Your Honor, so that I could have a full 24 hours to sleep. Okay. All right. I hear your frustrations and comments about the job. My question is, are you expressing those to the others who are, I do? Just a minute. Stop interrupting. You can't, when you interrupt too, it fucks up the court report and everything as well. Now I also wonder I don't know how much experience this person has litigating either. Also, I don't even know if these people are generally people that go before judges and stuff. They might just be paperwork lawyers. That's what I mean. I don't mean like that you're not a real whatever. But I don't know how much time they spend like presenting before judges or whatever. There's a name for this. Is it litigate? It's not litigating. I always try to find a word for this. I don't know if there's an official word for this. I feel like I heard it at one point, but okay. She said it was like her third week. Well, no, but I mean, I don't know if she had experience prior to this in some other district or whatever. It is litigator, is when you're arguing before the judge. Yeah, maybe it's just litigator. Just a minute. The others within the DOJ or ICE or DHS who have the role of carrying out the court's orders that require immediate release, how is that frustration getting translated? I read an email with big, bold font. I CC'd Ms. VOSS in it, and I said, here's where it fails. Some of this is just not recorded right. Here's what it failed, and we need to fix it. Here's how it fails, and we need to fix it. You can't just have people sitting in jail and drag me into court and explain to the court why the system fails. And if they can't help me, then I'm not here. I'm not meant for this job. And to be honest, Your Honor, I did put for a request to be transferred back, but no one was willing to come here to stand in front of you to explain and or to help to improve the system. Do you, Miss Lay? Because with this particular case, where it ended up is with the court having ruled that the petitioner had been unlawfully detained, and the remedy for the unlawful detention was that that person should be immediately released because they should not have been arrested and detained in the first place. Are you in any way defending the idea that for somebody who's been ordered to have been released unconditionally because they were unlawfully arrested, that the government or DHS or anyone should be imposing conditions upon their release that the court hasn't approved of? I am not defending it. That's why I have to go back and get them corrected, and it is corrected, but it took a fight, a big, huge fight to get that done and to move forward with the next case and the next case. Every day, every hour that we have tons of emails, and I pick up calls from any people that call, from anyone that wants to call to help with their cases regardless. So it is improving. It wasn't like that before, but because of my position as an ICE attorney in the past and a special attorney for the USA in the present, it took me a few weeks for them to understand that these are important conditions that we have to follow. These are important things that we have to do. If not, I'm going to put their names on the briefs and then you can bring them into court. That's not just you threatening me, Your Honor. I always go back and threaten them. It's like, this is what I mean. Okay, what did I say? Was it yesterday or the day before where I'm like, you got to have the bureaucracy. You need people who know how to do things. It really, truly does sound like we have like IQ drained our departments such that like these people don't even fucking know like what they're doing. They don't even know they don't know what the fuck anything is. They don't know what the fuck is going on. Destiny, this has happened. The institutional knowledge is gone. Yeah, so like 10 years ago when we were reading articles about how, fuck, dude, what was it like? So many people from the DOJ have resigned. We've lost 10,000 years of experience. This is going to be disastrous, blah, blah. And we saw those, like, what does that mean? Who cares? And whatever. No, this is what they're talking about, right? This is a lawyer who's working and they're saying, hey, we need to release this guy, and the chuds at like ICE are like, well, can't you just like fucking get the judge to sign off on it? They did it in the past. It's like, no. It's not the immigration judge. We have to go to another judge, a real judge. It's like, okay, isn't it like the same shit? No, it's not the same shit. We need to release these people or give a really good reason why we haven't. And it's like, all right, we'll get back in like 4 days on that. It's like, they were supposed to be released yesterday, unconditionally. And it's like, okay, well, we finally got them out. We did give them a lot of conditions though. I don't know what that can mean. Maybe curfew or maybe checking in with somebody saying, okay, well, that's not okay because that's not what the judge ordered. It's like, can't you just get the judge to sign off on anything? No, it's not that kind of judge. It's a real judge, not the fake bullshit ones that we've been going to in the past. This is really that important. I want you to understand my goal in any of this. It's not to threaten you or anyone. What we really want is simply compliance, because on the other side of this is somebody who should not have been arrested in some instances in the first place, who is being hailed in jail or put in shackles for days, if not a week plus, after they've been ordered released. That's my concern, is for upholding the rule of law and the constitutional rights of all concerned. And so that's my concern. I'm interested in compliance and not so much in threats, and I'm just trying to figure out how to get it. And I know that the government has a concern about the growing number of requirements that the court puts in place upon release of individuals. That happens because of the things we learn. For example, if we say, release the person immediately, then we learn that having transported him to El Paso or New Mexico, you don't bring him back. We learn that somebody is put out on the street with just the clothes on their backs and have to figure out how to get back here when they shouldn't have been arrested here in the first place, let alone flown halfway across the continent of North America, and so now we have to address that and have to say now, bring them back. And then we say, all right, so you brought them back. We can't have them released when it's minus 14 degrees outside. And so now we have to address that. Don't release them in the circumstances that might endanger their health or safety. And so once that's addressed, then we learn they've been released, but now conditions have been imposed. That somebody who should not have been arrested in the first place is now being told you're going to be released if you wear an ankle monitor, which the court didn't order because the person was unlawfully detained in the first place. Then we have to go back and address that now. I hear the concerns about all the energy that this is causing the DOJ to expand, but with respect, some of it is your own making by not complying with orders. Do you understand that? I do, and I share the same concern with you, Your Honor. I am not white, as you can see. Hey, ¿qué pasó, amigo? Hey, mi español, hey. I am not white, as you can see. And my family's at risk as any other people that might get picked up too. So I share the same concern, and I took that concern to heart. But again, fixing a system, a broken system. Hold on 1 second. I'm taking a bite of my delicious Taco Bell chimichanga. Nom, nom, nom. A broken system. I don't have a magic button to do it. I don't have the power or the voice to do it. I only can do it within the ability and the capacity that I have. And every cases I touch, I give it 100%. Never in my mind that one petitioner is more than the others. They're all important to me. So, but there are certain things that it takes 10 emails to get a release condition to be corrected. It takes 2 escalations and a threat that I will walk out for it to be corrected. I took it to heart, and the agency is slowly seeing what the court are doing, and it takes time for them to learn the lesson too and abide and comply with the court. I and Ms. Voss here are working day and night. Our emails just never stop. And as you can see, I would love to undo all of this stuff because no one wants to be in jail. And actually, honestly, being in jail a day to catch up with sleep is not bad right now at all with all the hours I have to put into this job. Ms. Lay, I appreciate your candor. There were 2 other cases here. I don't need to discuss them unless you want to take issue with the violations that the court found with respect to those 2 matters. No, Your Honor, but with respect to those, I figured out what the fail was when I didn't know that I have to do all the status follow-up when it's only like a small paragraph. That's, to be honest, I thought it was, someone else's job. And then I figured out everybody is busy. So the one thing that I've asked my colleagues and I to do is when you send out for a release, now click a few more buttons on the email, do a follow-up, and then a reminder. And that way the email will go on top of, at that date, at that time. And then we can fix these issues going forward. That's what I can tell you, bro. Can I get some employees over here? This is what I mean, by the way. None of this will ever come up in debate with any conservative because none of them fucking care about it. But this is what I mean when I say if you actually gave a fuck about deporting these horrible brown people from our country, by getting these illegals out of here, you really want to get them out of here, this type of shit should irritate the fuck out of you because this is not an administration that's serious about it. Even if you think it's base that they're not following court orders, it's so much more time consuming to do all of this shit in such a hacky, fucky, stupid manner. Because look how much fucking time you have to waste defending it, going to court, hiring people, doing email, all this stupid shit. Like, you could be so much more efficient if you just had the people in place that knew the process. Doesn't the administration prefer this incompetency and friction? It seems like courts lose legitimacy. No, they don't want this. They're stupid. They're legitimately stupid on some things. They don't know how to do their shit, right? These are the Trumps that we got, okay? In order of scariness, we have a stupid Trump with Bill Barr. This is not very scary because for all his right-wingedness, Barr was a competent attorney general. And he knew where the line was, and he knew how to follow process and procedure. We have something more scary than that now, and it's a stupid Trump with Bondi. Bondi's an incompetent fucking retard, or at the very least, the political cum clout has destroyed her ability to run the Department of Justice. So now they're ineffectual. Trump has wills and desires. He could express them to Barr, and Barr wouldn't do them. He can express them to Bondi. Bondi can't do them. The worst case scenario would have actually been a smarter Trump with a Barr who would have gone to Barr and said, here's the fuck shit I want to do. Let's figure out how we're going to fucking do it, okay? I want to do some real fuck shit. Help me. But instead he went to Barr and he said, Barr, I think that there are Italian spy satellites that are flipping votes in Georgia, and I need you to figure out how to tell that state to throw out their election. That's what we got instead. Did he actually say that about satellites? Yes. And then I figured out everybody is busy, and so blah, blah, blah. All right, Ms. Lay, thank you. You're welcome. You can retake your seat. I have some questions for Ms. Voss. Your Honor, may I have that document that I gave you earlier back because it's not redacted? I think I gave them all back. I think we have them, all of them back. Okay, thank you. Okay, Ms. Lay. All right, Ms. Voss. Here we are again. When this court issues a release order, who is the person or office responsible for being sure that it's carried out? Damn, dude, this must be the worst to have to defend like the incompetent as fuck government. When the government is your client and they're on some fuck shit and you're like, who's going to court today? Do you think they draw straws for this? Who's going to go and tell the judge why we've been late on the past 27 fucking emails? And it's not like on some remedial, it's not on some stupid shit. It's not like they were late, like, did we cross our T.R.? It's like releasing a guy from prison who never should have been in prison and is now halfway across the country. Like, it's on some real shit, on like some of the worst shit you can do. Your Honor, I take very much to heart your comments earlier. You're right. It is the executive branch, the entirety of it. DOJ has a role in that. DHS has a role in that. And it's both. Okay, I don't know why she's bringing DOJ here, but, well, so, no, that was right. I'm retarded. I just mixed up judiciary with DOJ. I just read that as Department of Judges. I just had a fucking stroke. Sorry. Okay, DOJ has a role in that. DHS has a role in that, and it's both. Well, so, within ICE, for example, is there a specific officer or unit, chain of command, that's accountable for execution of judicial release orders? Your Honor, obviously the agency is broken up into components, you're right, and some are council components and some are operational components. And I don't think either one of those is solely responsible. Both would have a role, but there is an operational person at the end. What is his answer? What is this? I feel like I'm watching, is it Kazam? Fuck, what's the name of the one guy? Where it's like, so what are the blockers you have on this project? Well, so me and the team, we went back and we analyzed the problem, and we're on a much better track now. We're definitely on track to, this product's gonna be delivered in definitely a week. There were a couple blockers, we got them taken care of, and we're making great progress now. We're gonna come back, and it was like, what the fuck did you just fucking say to me? What did you even say? What was his answer? The agency's broken up in components. Some are for counsel, some are for execution, and there is a person at the end of the day who is in charge. Okay. All right. So with whom does the buck stop? Your Honor, I think it stops with leadership. Certainly in my division, it stops with me and the U.S. Attorney. And the U.S. Attorney is answering to, so I have gotten, for example, quite a few responses for why a person has not been released as ordered. And I get responses back from the DOJ advising me as to when you all reached out to ICE and either haven't gotten a response back yet, or this is all we got back by way of a response, and which then makes this some opaque sort of shield that I can't really see behind to figure out why the orders aren't being complied with. And the answer cannot be that we called ICE and then a shoulder shrug. Yes, I understand that. Certainly, Your Honor. I think the respondents in each of these are the agency heads. You've got, obviously General Bondi, Secretary Noem. I get, and not to rudely interrupt you, Ms. Voss, at least I don't mean to be rude about it, but what I'm trying to understand is what happens here locally. If there's an order for release, I'm assuming the order for release doesn't go to Ms. Bondi. Well, make it plain for me. Your Honor, it goes to the St. Paul Field Office, which is housed at Fort Snelling. It doesn't just go to the building, does it? No, of course not, Your Honor. It goes to the agency counsel within that building, agency counsel that are responsible for this area, and it goes to the operational. Should I have a hearing and have that agency counsel come down here to answer these questions? Because I do want to know why the orders aren't complied with and why. We take no great pleasure as a court in compiling a list of some 90 or so cases of violations of court orders for release, let alone the 10 or so that I had just last week. And I want to figure out how to get to the bottom of where the issue is. Who is it, for example, that's determining that they're going to add conditions on a court's order for unconditional release? Who is doing that? Your Honor, I don't believe there is a policy to do that, so I don't know that that's being made purposefully at a higher level. I believe that's being done operationally by the people who are carrying out the function, and that, if anything, it represents a lack of training and communication from the supervisors down. Well, who's responsible for their training and education? Each field office director, Your Honor, I'm not sure in these particular cases. Usually in the cases, the field office director is named as a respondent. Mr. Eastwood, Ms. Rich is sometimes named as a respondent. Before this operation started, Metro Surge, did the DOJ or DHS anticipate that it would generate a large volume of habeas petitions and court-ordered releases? A habeas petition, I think, is basically just saying that, like, if you've arrested me, you need to read me my charges, or I need to get the fuck out of here. You can't hold me indefinitely without detention. It's a cornerstone of, I don't even want to say of liberal principles, of even in illiberal systems where people recognize the right to habeas corpus. You can't detain somebody without charges. In fact, it might be a right in everything ever. I don't even know if in a dictatorial thing, they usually just read you false. Even in North Korea, they'll make some shit up. Even in North Korea, they'll make some shit up to hold you, all right? Your Honor, I don't know the answer to that question. Do you know whether or not there were any additional personnel, systems, protocols that were put into place to ensure compliance with court orders that would arise from that operation? I don't know the answer to that either. And some of these may be questions better put to Mr. Rosen. Wait, is that the Rosen? The same one from the J6 stuff, who was the acting attorney general for a while? Or is it a different Rosen? I understand that. But at this hearing, that was Rosenstein. No, Rosenstein was an older acting attorney general, who is a fucking boss, by the way. I'm thinking of this guy. I'm sorry, I'll always love this.
Why can you answer that question? Because Nellie Orr worked for Glenn Simpson.
Organization that's trying to follow the rules, and we're going to respond.
You know what was interesting? When I asked him if he'd ever talked to Bruce Orr, he said he had. Said he had 3 times in 2016 and 2017. Then I asked him, have you ever talked to Nellie Orr? And he said, no, I haven't. I said, well, why can you answer that question? Because Nellie Orr worked for Glenn Simpson, worked for Fusion. He could answer that question, but he couldn't answer because FBI counsel told him he couldn't. He couldn't answer the question whether he'd ever communicated with Glenn Simpson, a journalist. Why couldn't he answer that question?
Mr. Jordan, I appreciate you saying it isn't personal. Sometimes it feels that way. How do I know, sir? I mean, you interviewed Mr. Strzok, I didn't, so I can't
Works
answer.
for you. Doesn't work for us.
There are 115,000 people who work for me, sir.
Mr. Rosenstein, did you threaten staffers on the House Intelligence Committee? Media reports indicate you did.
Media reports are mistaken.
Sometimes. But this is what they said. Having the nation's #1 law enforcement officer threaten to subpoena your calls and emails is downright chilling. Did you threaten to subpoena their calls and emails?
No, sir, and there's no way to subpoena phone calls.
Well, I mean, I'm just saying. I'm reading what the press said. I'm reading what
Well,
the press
I would
said.
suggest that you not rely on what the press says, sir.
Well, I didn't ask if there's no way to do it. I asked if you said it.
If I said what?
What I just read you.
No, I did not.
Well, now who are we supposed to believe? Staff members who we've worked with?
He's just so snarky. There are so many of these guys are so cool. These behind the scenes dudes.
Who've never
Fuck.
misled us?
Our government
or
is
you
fucked,
guys,
bro.
who we've caught hiding information from us, who tell a witness not to answer our questions. Who are we supposed to believe?
Thank you for making clear it's not personal, Mr. Jordan.
Well, I'm saying the
You should
Department of
believe me
Justice.
because I'm telling the truth and I'm under oath.
Under
If
oath!
you want to put somebody else under oath and they have something different
I
to
know
say,
these
I'll be
staff
happy to
members.
respond.
Then put him under oath and ask him.
Here's my last question. What's so important that you know that you don't want us to know, that you won't give us the documents we're asking for, that the House of Representatives is about ready to go on record saying you should give us? What's so darn important that you will threaten members, at least according to media reports and according to the staff members, threaten members?
Parliamentary inquiry, Mr. Chairman.
What is so important, Mr. Rosenstein?
Parliamentary inquiry, Mr. Chairman.
This is not an appropriate time for a parliamentary inquiry.
Okay, sorry. Anyway, apparently the Rosen guy was an appointee immigration. Not this guy, but anyway. What is Jim Jordan's position that I see him so much? Loud guy from Ohio, the worst state, because it produced Jim Jordan. And some of these may be questions better put to Mr. Rosen. I understand that. But at this hearing, I'm just trying to get to the bottom of how the court cannot have to spend so much time in just getting its orders complied with. And you have to concede, even before Operation Metro Surge, Ms. Voss, you've appeared before this court many times, and I'm sure never in your career have you had such an incidence of having to account to the court for non-compliance from the DOJ. When have you ever seen anything like this? I have not in my career, Your Honor. Right. So is it? Well, I'll stop there. You can retake your seat, Ms. Voss. Thank you. For the petitioners, anything you wish to say or add at this proceeding? May I approach, Your Honor? You may. Can you identify yourself again for the record? Thank you, Your Honor. My name is Kira Kelly. Kira. I need the Death Note music. I represent petitioners Oscar and Juan in these cases. First, I'd just like to revisit your question earlier of whether the unitary executive's behavior in Operation Metro Surge has outpaced the system's capacity to ensure that the Constitution is being complied with. And this is abundantly clear that the answer is yes. We see from this hearing today and from the abundant cases before this court and the other judges in this district that attorneys they're not being credentialed or properly trained or supervised, nor officers or agents of respondents from supervisors on down, Mr. Eastwood on down. There are problems with supervision and training that have resulted in immense violence to our communities that we hear that is now pulling teeth for counsel of record to get her own client to fix these constitutional violations. It should not be pulling teeth to get compliance from the government with the Constitution. And a question I have for the court is the party making it impossible for counsel to comply? Are they acting in blatant disregard of court orders so much so that their counsel sees her own self as a bridge between the court and the party here? That this is unprecedented. We know that counsel for respondents don't have the power to get their clients under control. An email with bold font is not going to change the widespread systemic pattern of disregard for court orders and honestly for basic human rights in this situation. Detained first, find authority later. This is exactly their strategy, and we've seen this from all of our cases where there's no warrant, there's no probable cause. Most of my clients, they report that respondents, upon detaining them, have no idea who they are. They're pulled over for how they look, or for where they are, or for any number of things that don't amount to probable cause under the U.S. Constitution. And I would point, Your Honor, to two declarations in a recent filing, which if Your Honor would permit, I could file in a supplement on this case. The first is a petitioner. It's an affidavit written by my client, Oscar, that it was filed at docket 67. The Advocates for Human Rights et al., whatever, versus U.S. Department of Homeland Security, case number law. And Oscar's declaration is important for a few reasons. One, it articulates just his horrific experience throughout this proceeding. And it's easy for us to see court orders not being complied with and the emails back and forth on the computer. But his affidavit really just shows what it's like to experience that, and in ways that were personally, for me, just sickening to read as his attorney. That he was without food, he was without clean clothes, he was subject to physical danger, both through reckless driving of ICE agents transporting him from one location to another, watching people screaming in pain with medical neglect, being exposed to COVID, just the conditions of his confinement, eating food that he conflated with dog food, that people are just being treated like less than human. And all of this has happened while he had a court order for his release. And while all this is happening, ICE agents are telling him to self-deport because he's got no chance to get out of there other than through self-deportation. So he's being deprived of access. And this is all in his affidavit. If anybody self-deported while they were in ICE detention like this, that's fucking crazy. That's crazy. Myself and his immigration attorney, who's here in this courtroom today, were not able to talk to him. His immigration attorney in particular made diligent efforts to ensure compliance with the court order, and these are emails that are in Oscar's case. I think you've seen these. We're trying to get a hold of him. We're trying to get access to him. We're trying to bring him home. And meanwhile, he is sleeping on the floor, if he gets to sleep at all, and he's being lied to, denied access to phone calls to call his loved ones or his attorneys. I would encourage Your Honor to read this declaration, and I would defer to the court if you would like me to submit it formally in Oscar's own case. Again, this is a thing where, like, I don't know if maybe people have more family around them, or maybe you have, like, working spouses. I cannot imagine, if you're working poor, I can't imagine being jailed for 2 weeks. I feel like I would have to kill myself. It's a whole pay period of work. You better hope that wherever you parked your car, it's not fucking towed. Okay, fuck, hold on. I don't know if I'm over-indexing on my working experiences. The worst fucking shit that can ever happen to you as a poor person, the worst shit, it is the ultimate fucking curb stomp ever, is getting your car towed. Because if your car is towed, chances are it's already fucked, okay? Because it broke down. So you're already somewhat fucked, number one, okay? Number two, bro, why the fuck? I don't know if it's just my experience or just Nebraska. Why the fuck is it? Do you know how much a tow costs? It'll be like $45. Do you know how much one night at the impound lot costs? Like $270. Why the fuck is it I go to get my car out the next morning and they're like, oh, that's going to be $350. If I had $350 fucking dollars, do you think my shitty 95 Dodge Neon would be broken down on the side of 370 because my alternator doesn't fucking work? And I wasn't, okay, let me come back in a couple days, okay, and I'll see what I can do. Oh, okay. Well, if you come back in 2 days, just, it's going to be like $600. Well, fuck me in the ass. Just fuck me right here. Fuck me right now. Yes! Fuck me. And you better hope you don't have anything outstanding either. Because if you have any outstanding shit that needs to be paid, they won't release you until I have that too. And you need your car to survive. Bro, if I was a fucking type 1 diabetic and it was like, do you want your car or your glucose monitor? I'm ripping the Dexcom out of my body. I'm like, fucking, I need my car. I can't live. How are you supposed to survive without your vehicle? I don't know, bro. That shit is crazy to me. Having your car getting impounded when you're fucking financially fucked is like, it is the worst. I'd rather have a cop beat the shit out of me. Just fucking kill me. Just please fucking kill me. Oh my God. Sorry. Of all the fuck shit to experience, more than cracking a wheel, more than popping a tire, more than whatever bullshit, of all the more than getting a speeding ticket, of all the fuck shit, it is having your car impounded. Oh my God. Oh my God. Oh my God. I just don't know why it costs so much once it hits the impound lot. Well, or maybe going to jail would be worse. Well, this would be worse. I've never been to jail before. Not really. So going to jail for 2 weeks, I guess, maybe that would be worse. Damn, that's a whole ass pay period. Gone. And the second declaration, also in the Advocates for Human Rights proceeding, docket number 29, was an affidavit that I filed, and that details my own efforts to work collaboratively with counsel, with respondents' counsel, I've been emailing and calling and trying to figure out how we can get these court orders complied with. There's an email in that docket 29 that I sent 8 days ago to ERO, to attorneys from the DOJ, the assistant U.S. attorneys, and attorneys representing ICE. Jim Stolley still haven't received a response. I'm begging for a means of clear communication, and I'm flexible. I'm sharing my personal cell phone. I'm saying whatever I can do to work with you all to get my clients home, let me know. To work with you all to get my clients' belongings returned, let me know, and I receive no response. And I think just this question of the overwork of counsel here, and I know we're all working above and beyond and not sleeping as much as we need to be, so I appreciate everybody for putting their effort in, and I invite the court to think about the root cause of the problem, the root cause of our collective overwork here, and the strain on our system with these repeated constitutional violations. We shouldn't need a specific court order to ask the DOJ not to put somebody's life in danger. But I can't tell you how many clients I've had to go find who were left on the side of the road with no coat, no phone, no wallet, no hat. They're wearing Crocs or whatever they got pulled out of their house or their car while they were wearing, and it's 0 degrees outside. And we shouldn't need a court order saying, don't put someone's life in danger. But here we are, and we need court orders or orders to show cause, to show compliance with court orders that shouldn't have had to have been issued in the first place. I think this would be a different story if these habeas petitions were frivolous, but we're filing so many because there are just so many people being detained without any semblance of a lawful basis. And there's no indication here that any new systems or bolded emails or any instructions to ICE are going to fix any of this. Like we need judicial intervention, and it has to be more than just having counsel be the go-between here, because I think we can see that counsel are being put in a position where they're working 20 hours a week, 20 hours a day, and it's not enough. If our system cannot keep up with processing these petitions to have rights vindicated, then we need to see what here is outside of the control of these attorneys. Where does the root of the problem lie? And sanctions to the party are within your inherent authority and are appropriate to bring this situation, this egregious, widespread pattern. You've referenced the 96 court order violations and counting just in part of January. We need this to be brought back into the court's control and into the Constitution's control. Thank you. Thank you. Any comment from? No, Your Honor. Okay, thank you. Anything further from the government? Not from me, Your Honor. Nothing, Your Honor. All right, court will take this all under advisement. If nothing further, court will stand adjourned. Jesus. These people
She was begging the judge to hold her in contempt.
I mean, they have like an impossible job.
Well, yeah, maybe they shouldn't be fucking doing it then.
True.
Like they should have time to figure it out before they just start fucking going in there.
Yeah, although, man.
I mean, I feel bad for her, but...
It's annoying because, like, I never really understood the how much of the immigration court stuff was Article 2 stuff, which is weird to me. I don't know, but it's not really worth it.
Well, it just feels like it's insane that they're trying to do search warrants.
That they're trying to do what they would need Article 3.
Shit.
Yeah.
Yeah.
It would be like
It's
me.
not
It would
even
be like
insane.
me.
I'll say criminal.
Yeah, it would be like me hiring private security for my apartment, but I call my security, these are the Destiny Police guys, the DGGP, the DGG Police guys. And then like 2 years from now, I'm like, oh, that guy was fucking loitering outside my apartment. I need you guys to take him, handcuff him. I need you to drive him to the fucking county jail and fucking put him in the prison or whatever. And it's like, what do you mean? Well, they're the police. They can do that. No, motherfucker. Those are your security. They can't arrest people and put them in jail. Like, Article 2, these are to sign off on administrative warrants saying that a person basically checking the process say this guy can be deported. It's not giving you the right to enter anybody's fucking home or car or pull people over. What the fuck?
Yeah, it's crazy.
That's not really the immigration court's fault, though. That's the ICE officers using the admin warrants. Well, but I'm not necessarily blaming the immigration court. I don't like the name. I don't like the names of it. I actually think it's important. I'm not normally like, I think a lot of the weird progressive, like people first language, like they're not a disabled person. They're a person with disabilities. I don't think any of that shit works. I don't think it matters. I do think in this case, I think it should be meaningful that you have different terms for things so that people know immediately what's going on. Like I said, I think that
court, is it?
Nah, it does. Like it resembles one. Like I think you can have hearings and everything, but it's all like it's just administrative stuff. It's not like a real like these are all nominated from within they come from the executive branch. Like it's not like a judge, you know. What's the talking point against the stupid ICE orders to get into people's homes? The talking point is just that it's illegal. You can't do it. It's not okay. You're not allowed.